All right, we are on the record in 2024 TR 617, State of Kansas versus Abel Estrada Jr. Please announce appearances.
State of Kansas appears by Assistant County Attorney Paul E. Dean.
Richard Paul on behalf of Mr. Estrada, who appears via Zoom at a separate location than counsel.
And how does he wish to proceed today?
Judge, I need to withdraw from this case.
Your Honor, Mr. Estrada filed pro se, I do believe. Well, I know it was pro se filing.
Well, I do notice he's taken a number of filings in his own right without going through counsel. Mr. Estrada, you come back to my recollection, we've met in city court, correct?
Yes.
And now this is that tag and suspended license?
No.
No,
It's a tag issue, Your Honor.
Just the tag, Your Honor.
All right.
I believe Mr. Paul is requesting to withdraw based upon the essentially.
This case started exactly how a lot of courtroom breakdowns start. Not with evidence, not with guilt, but with belief. The moment the attorney asks to withdraw, you can already feel where this is headed. When a defendant believes the system itself is illegitimate, every conversation becomes a fight before the case even begins.
Want one?
No, that's not it.
Excuse me?
I'm sorry, that's not it. He's not, Richard Paul is not seeking my interest. And I put everything in the affidavit. He's not representing me. He's actually judging me before, he's judging me before I even go into court. He's not listening to my paperwork. So he decided he doesn't want to represent me. So I still need to be represented.
Listen closely to what Mr. Estrada is saying here. He doesn't feel represented. He feels judged. And to him, paperwork equals power. That's important because emotionally, he believes he's doing everything right. But belief alone doesn't run a courtroom.
Now, I think you are going to have the same problem with any other attorney that you had with Mr. Paul. Mr. Paul, from this court's experience over the years, is a very competent, diligent attorney. Now, sometimes attorneys have to tell you their opinion of what's going to happen. And you may or may not agree with their opinion.
This is where reality enters the room. The judge is insulting him. She's explaining something most people don't want to hear. Lawyers aren't mouthpieces. Their job isn't to agree with you. Their job is to tell you the truth, even when you don't like it.
I proceeded to give all my information, all my laws, and he
All
doesn't.
of your what? Your laws?
The laws, the Constitution.
Your Honor, Your Honor, could I say
Please.
something, please? Mr. Estrada, every attorney who the court can appoint to represent you, one, I don't want to see, and I'm sure the judge is the same way, I don't want to see any kind of communication thread between yourself and Mr. Paul because there could be confidential, well, I'm sure there's confidential and privileged information within that, and you shouldn't be disclosing that to me. That's between you and any attorney you so choose to have represent you. But I believe most attorneys or all attorneys that the court has available to appoint to you, they are sworn to uphold the Constitution of the United States and the state of Kansas and not what you filed. That's the attorneys didn't go to your law school, which is kind of what you've set forth. So that's the issue the court's talking about when you're claiming a sovereign citizen. We don't have an attorney who's, I guess, registered to under your rules and laws as you see them. So
This exchange perfectly shows the sovereign citizen mindset without the label. My laws, my Constitution, my understanding. But courts don't operate on personal interpretations. They operate on precedent, statute, and procedure. That gap right there, that's where most of these cases fall apart.
Did you go to law school?
No, ma'am.
He did, you know that.
Yes, I understand, but he's not being constitutional. That's what I'm saying.
But you didn't go to law school, so are you sure you know what being constitutional involves? I mean, we all can read the Constitution and understand, yes, but there's a lot involved in interpreting that. Do you understand?
I understand what you're saying, ma'am. All I'm saying is that he's using case law, not constitutional law. And he didn't see all my paperwork. He just ignored it. He just blew through it and then gave me the wrong dates. I presented all the documents and he didn't even look at it.
This might sound harsh, but it's the most honest question in the room. Did you go to law school? Reading the Constitution doesn't make you a lawyer, just like reading medical books doesn't make you a surgeon. Courts exist because interpretation matters.
Let me ask you this. You are wanting a trial on this illegal display of a license plate or failure to display, right?
Well, no, I'd like to first, if we possible, if we can, a motion to dismiss with the stream
We're
prejudice.
not going to do that today. All right, I am going to one more time appoint you an attorney.
Your Honor, could I make a request to the court on this matter?
Sure.
This case carries a maximum sentence of 30 days. Doesn't even have an eligibility or requirement that he be provided an attornry.
Well,
I'm just.
there's
just saying,
potential jail time.
I would like to have if the court wants. I understand if the court wants to appoint an attorney. Absolutely, don't dispute that. That under the circumstance of the defense that's wanting to be presented, I would ask the court to appoint somebody. I get Mr. McClendon is still available.
That's just what I was thinking. He's here in town.
We set this next hearing, give sufficient time, perhaps 60 days, perhaps longer, and we just have it set for a bench trial. And if he doesn't want to cooperate with that attorney, the state would be asking for the court to proceed to trial, whether or not he can get along with the second one or not.
Well, it seems we're on the same page of thinking, counsel.
Here's what stands out to me. The court could have said, fine, represent yourself. But instead, they try again. Another attorney, another chance. That's not oppression. That's patience.
Would you join us for a moment? Were you in city court the night that Mr. Estrada, the gentleman under Motorola, had the tag violation?
Yes, Judge. You pointed me to his case briefly, and then Mr. Watson and I had a discussion and figured it would be more proper for a district court case.
Will you take the appointment if I give him back to you?
I guess, Judge.
All right. So you two have already met Mr. Estrada, right? The good news was he got it dismissed for you in city court, but the bad news is for you, it's back in district court. All right. So do you agree, Mr. McClendon, that we ought to just set it for bench trial, or maybe what do you want to do?
We can set for bench trial, Judge. I'm familiar enough with the case.
Okay. He has filed some pro se motions. Okay, Missy, give me a trial date, please.
We can resolve those motions at trial, Your Honor.
Sure. I just want to let Mr. McClendon know.
How about January 3rd at 11?
January 3rd at 11. Does that work?
Check my calendar now, Judge. Sorry.
Sure. Thank you. No problem.
That's fine, Judge.
All right. Thank you, Mr. McClendon. I appreciate your willingness to do that. Mr. Estrada, I will continue. You're not on bond, but I will continue the order that you reappear for bench trial January 3rd at 11. And I trust you have Mr. McClendon's contact information and he has yours from your city appointment?
Yes.
You do? All right. Thank you. If there's nothing further, we will be in recess on.
At the end of the day, this case isn't about a license plate. It's about control, about refusing to accept how the system works, while still demanding protection from it. And that contradiction? That's what gets people into deeper trouble than the original charge ever will.